Shadrach Obin hyphen Yabua. Shadrach Obin hyphen Yabua. Shadrach ends with a K, my lords. With a K. Nana Benin Akon. ACKON. Nana Benin Akon.
I said 5.
Yeah, I did the 5th one.
So okay, so he will be the last one.
He is the last one.
Yes.
Very my lords.
The name again?
Nana Benin Akon. ACKON.
Is it Akron or Akon?
Akon. ACKON. Akon.
Good. Yes, applicants.
Alos, we have a preliminary legal objection to the propriety of the application. And we pray that we take that one first.
Since you didn't file it, give us an idea so that we'll see whether
Okay.
we want to take you down formally.
Very well. Alos, this application was mounted on Rule 61, 1 of CI 19 as amended by CI 124. CI 16, no, 124. And my laws, case of such nature, the applicant is mandated to file the decision with application. It's mandated.
Oh.
With the decision.
Yes, any second ground?
My Lord.
Also, this is a point you have made which is well known. The rules say so, not so.
And they did not file.
That's right.
It with a decision.
Okay.
My Lord, in the case of.
Oh no, I said, is there a second
only one
ground?
point.
That's the ground.
Only 1 point, yes.
No, I think having regard to this is a matter that we have. If the decision is available, we normally prefer to determine it on the merits.
Hellos.
No, what does since the decision is before the court, or determine the application on the merits, having regard to the nature of the case. So, I think. No. We see, we don't want to drag on matters which are trite. You have a point. You have made it, but the court has. You have mentioned non-compliance with the rule.
Yes.
And the court has power to waive it. And the court has waived it and said, since the decision is before the court, let's hear the application on the merits. And you have done it. You have argued on the merits.
My Lord, this court has taken the decision. Yes. That's for Colombo.
Before the court. Do you have a supplementary affidavit?
Yes. Yes. Yes, we don't have it. And this court made a decision on this particular Colombo and indicated that you cannot even file supplementary affidavit. You cannot file it. Let alone to exhibit it. You cannot file it. You cannot file it, my lord. It is here. This is here.
Counsel, you are appointed.
Watch why Japanese people eat white rice.
Rice is pure glucose in starch form. It is one of the fastest ways to raise your blood sugar of any of the starches. But the Italians are very clever with their starches. They purposely undercook the rice in their risotto, so it takes much longer to break down the starches in those two foods. It turns out 4 to 5 billion people use rice as their staple, and yet almost all of them use white rice rather than brown rice. Places like Japan, which are famous for their long lifespan, almost
pointed out non-compliance we have waived it because the decision is before the court.
Very well.
I want to hear the application on the merits. Yes, applicants.
My Lords, we have before you an application invoking the supervisory jurisdiction of this honorable court. My Lords,
Yeah, our recording system is working, so we don't have to write everything verbatim.
grateful. My Lords, I move in terms of the motion paper the grounds set out in the motion paper, the affidavit in support, yes, my Lord, the supplementary affidavit in support, the statement of case, and the exhibits annexed to the application. My Lords, our ground for this application is that the order made the orders made by the High Court were made in breach of the applicant's rights to be heard. My Lord, the further ground is that the trial judge demonstrated apparent bias and partiality. 3, that there was a non-jurisdictional error of law by failing to exercise the court's powers under Order 55, Rule 5(2) of CI 47 to direct second to sixth interested parties to serve the mandamus application on the applicants who have interest in the subject of the dispute. And finally, error of law apparent on the face of the record, which error of law occasioned a substantial miscarriage of justice to the applicants. My Lords, I wish to draw this honorable court's attention to exhibit my Lord, to exhibit 5 series. Oh, sorry. My Lord, a brief fact I think will be important in this matter. My Lord, an application for mandamus was filed before General Jurisdiction 13. Now, at the hearing of the said application, after counsel for the applicant and the respondent announced themselves, I drew the court's attention to a joinder application. The trial judge,
Go ahead.
yes, the trial judge requested I show him a copy of the joinder application. He therefore asked his clerk, a lady clerk, to come for a copy of the joinder application, looked at it, and proceeded to write his ruling. My Lord, the ruling we have exhibited to the supplement, the supplementary affidavit, as the B series. My Lord, in Exhibit B1, the trial judge clearly indicates, and my Lord, with your permission, I just want to read the portion. Page 2 of the ruling. So, therefore, the joinder application notwithstanding, it is not safe. An offense rule 20.
Now help us. Which of the applicants' ruling are you reading?
Oh, my Lord, with respect, that's
Mine actually is the rulings are exhibited as Exhibit A.
yes, but in the supplement it comes as Exhibit B series.
Okay, I have it as
in the supplement.
Okay. Now, which applicants?
Most people have no clue that in 2024, the best way to make money with Amazon is not with physical products. It's Amazon's other company, Audible. Audible has been paying me a steady and reliable income every month for years, and I'm not the only one. People like Katrina, Carmen, Elena, and Renee are all enjoying a significant monthly income using the same system.
Just this past month, I reached $8,000 in revenue, and I'm on track to reach $10,000 in revenue this month.
I've been able to go from 0 to 22K in 7 months. And of course, this completely changed my life.
I do this on a part-time basis, about 5 to 10 hours a week. I earn about $40,000 a year. There's no other job that pays with that little time.
And the best part...
ruling are you talking of?
This is my Lord, this is the fourth applicant's.
No, we have Nana Equia also a free ruling. We have
the one I have with me is that of fourth applicant.
Mention the name because we have.
Amenope Philibert.
Okay, that's it. There's Patrick Yabuama.
That is so, my Lord.
There is James Acosta.
But this one is Expert Frank Ano Dompre.
This is what we are looking.
Oh, very well.
Because that locates it easier for us.
B1.
Anyway, but once we get the name of the applicant.
Expert Frank Ano Dompre.
Not them.
Page 2 of the expertise and not on prayer ruling.
Just 1 minute, just 1 minute. There's so much paper.
So, my Lord, with respect, exhibit B2.
Okay.
Expertise.
Which one are you reading?
Expertise Yao.
Which one are you reading from?
So, my Lord, I wanted to read Expertise Frank Anodompre, page 2
yes.
of the ruling.
Yes. So now we're on the same page. Yeah.
Yes. So it then says, therefore, the joinder application notwithstanding, it is not said an offense or that 20 Rule 14. The application is granted as prayed, and the respondent hereby is ordered to collate and declare the winners of this election. So it proceeds. Yeah. My Lord, again, in exhibit B2, Expertise Patrick Yabuama.
Yes.
At the same page 2. Quote, therefore, the joinder application notwithstanding, since it is not said an offense Rule 20, the application is hereby granted.
Yes.
Exhibit B3.
Now, so, and your point is?
The point we are making is that at all material time, The fact that was before my Lord was that the applicant herein, whose interest will be affected by that decision, ought to be heard. And that failure to afford them a hearing before the decision was given offends the Odi Aterium Parting Rule. And that offense cannot be cured and should result in the invalidation of the decision by the trial judge. My Lord.
Counsel.
Yes.
So you hinge it on the application for joinder. Failure to grant you a hearing is anchored in your application for joinder.
No, my Lord.
Is that the case?
No, my Lord. First of all, my Lord, I just want to draw the court's attention to something. Yes. Order 55.
Yes.
Says 2.
No, let's look at the issue of joinder first.
Okay.
Yes. So as far as the failure, alleged failure on the part of the trial judge to hear you, your case is anchored in the application for joinder, whether partly or wholly.
No, my Lord, maybe partly.
All right.
Even without the joinder, with respect, even without the joinder, by reason of the provisions of Order 55, 6, Rule 5, 2, it says.
Hi, my name's Dr. Frank Schallenberger. I'm 77 years old, and although I may look my age, I don't actually feel my age, not even close to it. In fact, if you were to measure me on all the usual markers of aging, you're going to see that I'm actually decades younger than my age. For example, my lung capacity is 102%, which is 2% higher than the average 40-year-old. My functional strength is 115%.
That a notice of application shall be served on all parties named in the applicant affidavit as being directly affected by rate. 2, the court may order that the notice of the application shall be served on any person not named as being directly affected by the application if in his opinion it's desirable so to do.
So that is the Order 55 prescription.
That is 55 prescription.
Yes. And you mentioned the joinder application, so I'll bring you back. Now, your application for joinder was based on Order 4. Was that the case?
That is correct.
If you have your rules with you, look at Order 4, Rule 5. Order 4, Rule 5, Sub Rule 5. You may start from Order 4, Rule 5, Sub Rule 3. The provisions there indicate what must be done when the court decides to grant an application. Can you read 4 Rule 5.5?
Yes. Okay. It says, where an order is made under sub-rule 2, the rate shall within 14 days after the making of the order or any such period as may be specified in the order be amended accordingly.
So,
and thus, with the reference to the order in pursuance of which the amendment is made and with the date on which the order for the amendment is made.
So it talks about a rate.
That is correct.
Yes. Turn to Order 82. A rate has been defined by the rules. I think it's the very last word.
Yeah, the definition.
Under the interpretation section.
Yes.
What does it say?
My Lord, it says a rate includes a rate of summons, statement of claim, or a petition in a cause or matter.
So it doesn't include the application before the trial judge.
My Lord, it's an originating process.
Yes, but it's not a writ, as defined by the rules.
You see, my Lord, the word used is includes.
Now, would you say that the provisions in Order 55 are cognizable to the joinder and Order 4?
My Lord, the provisions
yes.
of Order 55.
Yes, because you see, by your own showing, Order 55 has prescribed means by which the court can hear a party whose interest will be affected. You understand?
Yes.
By service of the affidavit. So would you say that that provision, an application under Order 55, will recognize a joinder application under Order 4?
My Lord, it should. And my Lord, the reason is that, my Lord, with respect, the reason is that the rules on joinder,
yes,
unless there is a specific provision detailing how an originating process should be done differently other than Order 4 is applicable. And my Lord, if you look at the reasoning of the trial judge,
yes,
he did not reason that the application was brought pursuant to Order 4, for which reason he was not going to hear it.
Having said that,
so I'm just pointing out.
I was asking whether, given that Order 55 has prescribed the means by which the court may hear a party whose interest will be affected, there is a need to even call in Order 4, and whether Order 4 has legal basis.
My Lord, a quick
in a judicial review application.
My Lord, we notice that the issue of natural justice,
yes,
is a constitutional matter.
Yes.
And the rule cannot, as it were, defeat the intent of the Constitution. That to the extent that a person will be affected by a judicial decision, that person ought to be heard.
Yes.
With or without the rule. And so the issue of the rule coming in aid with the greatest respect does not even arise. We are raising a fundamental question that relates to the rules of natural justice. It cannot be said that Order 4 or any other rule, if not complied with, satisfy the requirement of hearing. It cannot be the case, with the greatest respect. 2.
Yes, proceed.
In addition, my Lord, even without Order 4, my Lord, it is even in the interest of justice and fairness, which this court is supposed to uphold, that a person who will be affected must be heard. And in this case, with the greatest respect, that was flatly ignored. And so, my Lord, the point we are making, that decision or the orders founded on that refusal to hear the applicant, even when they themselves came to the court. My Lord, should not, with the greatest respect, be endorsed, because the precedent will be dangerous as far as the rule of law is concerned. My Lord, 2.
How, in what sense will the precedent be dangerous?
No, my Lord, the point I'm making is where a party, in fact, maybe let me put it this way, 2 parties can actually collude and overreach a person who will be affected. And that precedent is dangerous. And in this specific case, when the application for mandamus was moved, the judge asked counsel for the respondent, are you opposed? He says, no, I'm not opposed.
Does that make it?
No, I'm not saying so. My Lord, I will say so. My Lord, I will say so. But the point is that if this is allowed, that possibility is so grievous and present. And that is why this court must deprecate, with the greatest respect, that conduct.
Also pay attention to the affidavits in opposition,
yes,
and then the statement of case in opposition.
Very well.
Address them.
My Lord, with the greatest respect, and I want to draw this court's attention to judicial review application. Or judicial review application. My Lords, exhibit attached to our judicial review. My Lord, we attach exhibits, that's the Republic versus High Court, Electoral Commission Respondent, National Democratic Congress. My Lord, it's in the supplement. Yes, so my Lord, I'll be very specific. I have a supplement.
Is it a problem you have created for us? Some of the exhibits, I have them as B, and my other I have it as A or C. Is the problem you have created for us?
My Lord, I'm sorry. I'm sorry about that.
Unlike the other party who have actually flagged.
My Lord, that should be exhibit D in our supplement.
D.
Is the application for judicial review by the NDC.
Yes, you made the point, and let's see if it will help us locate.
Okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My Lord, they were before him.
I saved $700 with Liberty Mutual. Crazy what you can get with those savings.
Yes, I stood up. Yes, my Lord, that's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even filed ours on the 16th. On the 16th of December. This mandamus application was filed on the 17th. But my Lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same.
Oh, okay.
Was it pending in that court or it was right before him?
No, it was pending.
Say so.
And he was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. Now, my Lord, these are declarations with video evidence. So consider my application first. He ignored it.
I lost respect.
Yes, Counsel.
You see, some of the facts being heard on this court are indeed erroneous. They are erroneous. And I think it's fair that I put them in context.
Okay.
The process he filed.
Counsel, you can read.
No, just hold on.
Please. What he filed was not before the judge. It was not before the judge.
No, it may not be on that docket.
Was listed.
It may not be on that docket, but it may be in a separate docket.
No, fellows. He came to court holding the documents.
No, we're talking about the second application. Or the one application. The first application, the one they filed on 6th.
The one they filed.
The first application. Okay. So, Mr. Tamaklo, yes. Continue.
So, my Lord, at the time my Lord considered, he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he had it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he would do it and started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared during the mandamus. He knew that that would definitely affect their rights. My Lord, on the grounds of bias, my Lord, the point we make here is that at the time, with respect, my Lord was considering the mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he is done hearing, our application for judicial review would have become moot. Manifest bias. My Lord, 2. The mandamus application, in one breath, my Lord says, our joinder, on page 2, offense under Rule 14 of CI 47. However, my lords, the mandamus application that was granted, with respect, had no statement of case attached. So in one breath, my Lord was holding us to the strict compliance of the rule, but in the other breath, waive it for the interested party. My Lord, without the statement of case, the court's jurisdiction for the mandamus was not properly even invoked.
Could a Cybertruck, like the one that you see right behind me, pay you $30,000 a year? I'll admit, it sounds like just another crazy idea from Elon Musk. But I'm about to get into this Cybertruck and drive up to a location just a few miles from here to show you how this is possible. Hi, I'm Jeff Brown, a former senior executive of 3 major public tech companies, Qualcomm, NXP Semiconductor.
And so the orders founded on it were definitely done in excess of the court's powers or its jurisdiction. We submit.
What is your authority for saying that?
About 65 Rule 6. 2.
It says what?
6.2. The court made on the hearing of an application for judicial review. Then 2, within 14 days after the filing of the notice of application, the applicant shall file such numbers, such copies of the applicant's statement of case. And my lords, this court, in the case of and Nitete Ahinkwa II and Thomas Okai, civil appeal number J4 2009, dated 29th April 2010. His Lordship Justice Badegbe had this to say, that when J4/20/2009, it was dated 29th April 2010. It says, quote, where the rules of court prescribe a particular mode of seeking relief, then a failure to initiate the proceeding for relief in accordance with the prescribed mode is not only an irregularity, but raises an issue that goes to jurisdiction. Now, in excess of jurisdiction, specific. In the case of Francis Owusu Mensah and another, versus National Board for Professional and Technical Examination, civil appeal number J4/57/2017, dated 1st May 2018. It was held.
Council 57 or 67?
57. Eniegwa JSC, as it then was, had this to say. A court may have jurisdiction to entertain a cause or matter, but the procedure invoking its jurisdiction may deny the court's jurisdiction. In this case, the court, the High Court, has the jurisdiction to entertain a mandamus application, but the rule says, at the hearing, a statement of case must be attached to the application. That is how the court jurisdiction is invoked.
Mr. Tamaklu,
my lord,
even in this court, your colleague raised a fundamental issue, preliminary objection, which we have waived.
Oh, my lord, I take it that you are willing to waive this one.
And we said that, look.
No, my lord, when you waived, it was on record as having waived it.
So it's...
In this case, my lord, the ruling of my lord is before you. The court never said they are waiving that non-compliance. My lord, the court never said that. It is a different thing if the court, in exercising its powers, gave an indication on record that it is waiving that non-compliance. That was not done. My lord, it's a court of record. Yes. My lord,
does it matter to you that the other side did not file an affidavit in opposition? Does it matter to you?
Yes, my lord.
That the EC before the High Court was not opposed to the application.
My lord, the
waiver even started with the EC.
No, my lord, the waiver is not one that the party should raise. With the greatest respect, it's not one that requires that a party should raise an objection to the non-compliance.
Why? The party may raise it.
Yes, I'm saying that without that, this court is required to consider it.
Did Harvard University just find a way to restore crystal clear 20/20 vision without glasses?
Yes, my lord. My Lord, what we are basically saying is to just draw this court's attention to the nature of the bias. That in one breath, he holds us strictly to the rule. And my Lord, that is even denied. The joinder application had a certificate of exhibit with the greatest respect attached to it. Yeah. I will. Yes. I'm not afraid there was no exhibit. Yes. So, my Lord, I'll just read the ruling.
Oh no, which one? On your non-compliance with the rule?
No, the issue of the manifest bias.
Okay.
My Lord, Exhibit B series, ex parte are not on break.
Yes.
My Lord, there was no exhibit attached. So the issue of certificate of exhibit does not even arise. But my Lord said we had offended the rule.
Okay.
My Lord, 2. Ex parte Nana Equia Owusu Efriye. That one, we attached a video recording of the declaration. And there is a certificate of exhibit attached. But my Lord simply says he is applying the ruling mutatis mutandis. My Lord, I want to bring to your attention the decision of this court in the Republic versus High Court Bogatanga. Ex parte Hawa Yakubu, 2001-2002 Supreme Court of Ghana Law Report at page 553, sorry. The Supreme Court had the occasion to quash the orders of the High Court in Bolga because the court said Hawa Yakubu, who had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said she had the right to be heard, and that right was breached. And all the orders made by the High Court in Bolga were quashed. And the resulting effect that all the consequential orders, having been founded on those orders, must collapse with it. My Lord, the affidavit in opposition filed by the first filed by the Electoral Commission the position made is that because
proceed.
Because the applicants were not parties at the time the application was heard, they deserve no rights, or there's no issue of breach of the rules of natural justice. My Lord, that is completely far-fetched. Because the application for judicial review, which had the video recordings of those declarations, was duly served on the respondent. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. Or if he only stood up and said he's opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. There is a new. And that is exactly the decision of the Supreme Court in S. Party Howard Yakubu. My Lord, at this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission, deposed to by Mr. Samuel Tete, be expunged from the records of this court.
Why?
My Lord, these are matters that are not within his personal knowledge. He is not the returning officer of any of the constituencies named.
I think he preceded his affidavit by stating that within his knowledge and information, didn't he?
No, the point we are making is that.
Have you heard about the salt trick that's making men stay hard for hours in bed? Man, listen.
With the greatest respect, my Lord.
Yes.
One, he does not attach any official record or official document to the deposition or a police report by any of the returning officers detailing the so-called
that weakens the weight.
Very well.
I don't think we...
No, my Lord, I just want to bring it to you that those depositions should not be responded to.
Oh, no, we said that, the man stated that to his information. If he thinks that it doesn't actually establish a fact, that is a different matter. But you can't, don't say we should expunge it.
My Lord, the respondents say they had already done the collation. And so what is the point, you considering our application? My Lord, the morning of that Friday, with the greatest respect, I had appeared at General Jurisdiction 6 with my learned senior Justin Amenuvo and Gary Limaku, where there was a pending injunction application against the Electoral Commission. That my Lord,
my Lord, so far, various allegations have been made in this court in the course of his submissions, which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
No, counsel. If he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the needful. So anytime he's going beyond his affidavit, draw our attention. Yes, counsel.
So we have a... Please restrict yourself to your affidavit and let's go on.
Yes, my Lord. So,
we don't have
my Lord, my Lord. So our response is that at all material time, there was a pending injunction application that we had all appeared before the judge and gave us Tuesday.
My Lord, this is not before the court.
Okay. So you haven't deposed.
It is not in your affidavit.
You haven't deposed to it. So let's go on to another point.
My Lord,
You were addressing us on what you said is the argument that the declaration has been done already. So address.
My Lord, our quick response is that, in fact, in the Hawa Yakubu decision, orders were made, and those orders were even complied with. But when it was brought to the attention of the Supreme Court that there was a fundamental breach of the rules of natural justice, the decision and all the consequential orders founded on it were all set aside. My Lord, it is on this basis that we make this prayer. Yeah, I'm in the motion. So, my Lord, it's on this basis that we invite this honorable court we urge on this honorable court to quash the orders of the High Court General Jurisdiction 13, my Lord, maybe just a quick point. In paragraph, my Lord, with respect, in paragraph 10 of the 2nd to 7th interested party affidavit in opposition, particularly paragraph 10, it is deposed to the fact that our joinder was heard.
Yeah, that's their case.
That our joinder was heard and dismissed. Yes. My Lord, with the greatest respect, the joinder application was treated in a very cavalier manner. Cavalier. In fact, it was not moved.
My Lord. The problem I'm complaining about. What you are alleging, my Lord, is not captured in our affidavit.
Is that paragraph what?
To the paragraph where you said the joinder was heard. A joinder which was on the docket, how can it be heard?
No, I think their case is that the court gave you a hearing.
Yeah, that's what I'm responding to. And I'm saying that we were not heard.
So it's different from saying that the joinder was.
We were not heard. And my Lord, nowhere in my Lord's ruling did he say, with respect, that he heard our agenda and dismissed it. Nowhere. In fact, he himself said he will not allow the joinder to affect the quick hearing of the application. How can that same joinder be deemed to have been heard?
No, he said he gave you a hearing on the application.
Yes, my Lord, and that is why we are.
So it's not the joinder. He had before him an application for.
What if I told you there is no such thing as no internet? This brand new portable Wi-Fi router provides more features than traditional internet services without ever having to pay for expensive installation fees, contracts, or hidden surprise charges, making typical internet providers totally outdated. It's called Ryoko, and it was developed by 2 former employees of a cable.
Mandamus. Their case is that when you appeared, he heard you on the application for Mandamus.
No, my Lord.
No, I'm trying to get you to understand their case. You are misrepresenting their case.
Very well. So, my Lord, the point we are making is that we were never heard on the application for Mandamus. Because first we were praying that we will first be joined, then we'll be heard.
Mr. Tomekulu, I'm reading something from Nana Akua Owusu, a 3 years exhibit. I think it's the first one.
My Lord, 1 minute.
Yes, I have it as A series. The one in respect of Nana Akua Owusu Afriye.
My Lord, I want to just locate my.
I believe it's in yours as B series.
Okay. No.
The original is
okay. Yes,
you found that?
Yeah. Is it the mandamus application?
Yes, the ruling, yes.
And the ruling, oh, okay, we attach it to our supplement. That's the B series.
Yes, I have it as A series, but fine. But the one in respect of Nana Akua Owusu Afriye.
Yes.
Have you seen the ruling?
Yes.
Please read the first paragraph of that ruling. It's in connection with whether or not you were heard.
So,
can you read it?
Yes. The application of on the face of it is not different. And notwithstanding the submission of a friend of the court in the person of Godwin Kudu Ebiji Tamaklo to the effect that the winner of this constituency has been declared. And he proceeds, which no evidence is before the court, except an application yet to be moved.
Yes.
Yes.
So you made a submission?
No, the submission is to draw his attention of the pending joinder and the judicial review. And notwithstanding bringing to his notice. In fact, he described me as a friend. A friend of the court. At that point, I was not counsel for a party.
But you were not. You were not a party to the application. Perhaps that was why he decided to describe you as such.
Yes. No, my Lord should see representation. You see that there is no record of me being a representative. See, counsel. Oh, my Lord, just to draw his attention.
Anyway, we still have two other lawyers here. So
my Lord,
you
so,
wind up.
My Lord, on this basis. So, my Lord, this court has on many occasions upheld the fact that a person to be affected by an order or a decision should be heard. My Lord, within this context, a failure to do that, my Lord, will be a serious affront. That affront to the rule of law, constitutional the other party. The Supreme Court, and my Lord, I conclude here. The Republic versus Court of Appeal, Anthony Tomford, ex parte Ghana Chartered Institution of Bankers, 2011. 2 SGLR, page 941. The Supreme Court, speaking through His Lordship Justice Atuguba, held that the terms of Article 296 are mandatory and obviously require the observance of the rules of natural justice, especially the Odi Alterum Partem rule involved. That Odi Alterum Partem rule has been elevated to constitutional pedestal, and this breach has constitutional consequence. My Lord, and said breaches void the act in question. My Lord, it's on this note that I draw the attention of this honorable court with respect to grant the application as prayed.
All right, thank you. Counsel for
Yes, my lords. My lords, we are opposed to this application and rely on our affidavit in opposition and the statement of case in support of that affidavit in opposition. My lords, except to add.
If you want to slim down, skip breakfast. True or false?
Here's how it works. Around 3 to 4 hours after your last meal, your body begins a fasting cycle and starts utilizing its own glycogen storage. After your body depletes its glycogen, it starts looking for a new fuel source. And when you get things just right, your body can actually start consuming your own fat storage for energy. This process produces ketones, leading to more and more fat loss. But if you start pounding a carb-heavy breakfast, you slam the brakes on all that fat burning because your body goes back to burning the sugar you just ate. See, your metabolism determines how quickly and effectively your body
that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, not a single one of them, has deposed to an affidavit in this court General Decision 13 just saying that Electoral Commission go and perform and complete your constitutional duty. None.
Oh, you mean the individual applicants?
Yes, my lords. There's none before you. They have not deposed to
How about the first applicant?
My lord, the first applicant is not a party who has stood for election and for which he is claiming that he has an interest. He's an official person. These are individuals. The first applicant will not go to parliament. It are individuals. They are before you. They have not said anything. My lord, well, he said he has sponsored. Let the sponsorees, it's the sponsorees who go into parliament, not the sponsorer. My lord, the second point I'm making is that I'll refer the court to the case of Bobier versus 21st Century Construction Limited. Another civil appeal number J4/5/2014. It's a judgment of this court dated 9th March 2016. Suit number J4/5/2014. It's a judgment in which my Lord presiding and his brother now retired Justice Badegbe delivered a ruling, and their ruling touched on the effect of Order 5, Rule 1. Order, my Lord, with respect, Order 4, Rule 5.1. And with your kind permission, if I may read.
CI 47.
Of CI 47, my Lords. No proceedings shall be defeated by reason of misjoinder or non-joinder of any party, and the court may in any proceedings determine the issues or questions in dispute so far as they affect the rights and interests of the person who are parties to the proceedings. My Lord, even if we transpose this originating notice application into a writ, by this rule, the court has the right.
Why do I not a writ? Why do you
no, that's why I use the word even if. Okay. Even if we do that, the non-joinder will not defeat the proceedings. The court has a right to go left or right, and if it does, their course of action is one of appeal. So far, in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore the Surera should lie. Respectfully submitted. Thank you.
Oh, counsel.
Why?
But you argued Hawa Yakubu in your. You argued Hawa Yakubu.
Yes, my lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No. My lord, the order had an injunction placed, but in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder, but you can question it on other parties.
Yes, my lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my lord. And then also, one last thing, now that you have brought it up, my lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my lord will look at it as an application. My lord, there is an application because of the way the numbering is managed. I'm not able to. It is an application. Let me give you. My lord, let me give you.
Counsel, take your time.
Oh, my lord. Well, my lord, this is the application dated 16th. It was filed on the 16th of December 2024. My learned friend made reference to it.
If you've been wanting to grow on YouTube, go viral on social media, or even just shoot videos as a hobby, this is the best way.
But in that particular matter, he hasn't brought the ruling of the court. There is a ruling of the court on that particular application. So, my lord, to wrap up, none of the applicants before the court has made. Yes, thank you. I'm most grateful.
Okay. Thank you very much for saving our time.
I like the word mania.
Yes, Mr. Nimako.
My lords, we are also opposed to this application. We filed a legal position in civil case on the 25th of December 2024. We rely on all the depositions made in the affidavit and the exhibits attached. And the authorities listed in the statement of case. My lords, this application on the document of the court, which all parties to the action were not served with a said application at the time when you were dealing with the mandamus application. My lord, we submit. The application for joinder was indeed a non-starter. That is because, my lords, there are specific rules dealing with mandamus application. And my lords, in Boifio, NTS for properties. But if you, it's NTS for properties. 1996, 97. IGLR 531 at 533. This court held that the law was clear that where an enactment had prescribed a special procedure by which it was that procedure alone that was to be followed. My lords, Order 55, Rule 5.2 has provided for the procedure by which notice of an appeal for judicial review can be communicated by the court to any affected party. That procedure is not joint application. The court may order that notice, and it is may order that notice of the application shall be served on any person not named as being directly affected by the application, if in its opinion, an opinion of the line, desirable that the person should be given notice. It is a rule, my lord. It is a rule, not by joint application. And my lord, this is a discretion which a court has to exercise. It's a discretion. It's a discretion. And if a court exercises discretion, whether rightfully or wrongfully, the aggrieved party, if so minded, cannot come by judicial review. The nation should arrive.
What is your authority for that?
My lords, if I may refer this honorable court to page 3 of my single case. Page 3. Republic versus Court of Appeal, as per the Jurisdictional 2005-2006.
Oh, read the report.
Read the report. Very well.
If you have the report there.
Yes, yes. The clear thinking of this court is that.
What page are you quoting?
Page 619. 619.
Yes, yes.
The clear thinking of this court is that House Supervisory Jurisdiction and Article 132 of the Constitution should be exercised only, in the word underline only, in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to the jurisdiction or are so plain as to make the jurisdiction a complete nullity. My lord, if I may even
I get the point, but you see, you would agree that the ex parte Chachikata case and the ground that was being discussed by Georgina Wood, JSC as she then was the ground of error of law. Let's pay attention to the fact that they also have a ground of failure to observe the odi alteram pattern. So, yes, if it comes, your point holds. Also address the area of the failure to observe the order altering pattern rule.
Yes.
You have argued it, but I think you should expatiate on it.
My Lord, we stop it. That a non-party to a suit cannot complain. That his right to fair hearing has been breached. In this case, my Lord, I saw the Republic versus High Court, Accra. High Court, Accra. Ex parte, Danso, and others. In 2015, 2016, one LGLR at page 760. 760.
Senior homeowners in the U.S. are putting $1,374 back in their pocket this year from the savings with this new.
One Supreme Court of Ghana law report at page 760. Holding one. This court held in dismissing application for judicial review as follows. That in spite of the affairs ground by the applicant alleging breach of the right to fair hearing being a fundamental right that is available to parties to an action, this court is unable to extend its scope to persons who have not, on the record, yet become parties strictly so as to speak. My Lord,
but there are several decisions. Republic versus Colleague Magistrate, ex parte Amponsa, which has been cited by Amenuvo. They said that as for certiorari, their public law reliefs, you don't have to be a party. And then we have
about capacity. It is an order.
No, I just want to say that the general blanket statement may not be true because there are alternative authorities. If in this case you want to make a distinction, fine, but judicial review is a public law relief, a non-party can come for it. Ex parte Adavali and so many other cases.
Yes,
but make your point.
Yes, what else? So the point we are making is very simple. The High Court only made an order directed at the public body to perform public function. To simply go and collate and declare a winner of a public elections. And my Lord, I believe that all of us here are interested in who is the winner or a loser in our elections. So that order, who the court made for the EC, the first to go and collate and declare who has won or who has lost, my Lord, it's a public function. It's a public function. How does that order to go and collate and declare the winner or a loser of our elections affect somebody injuriously?
Oh, look at your Exhibit 9. Look at your Exhibit 9. D9. Your Exhibit D9.
My Lord, Exhibit D9.
Yeah, D9 is supposed to be, I don't know what I would call it, the collation sheet.
Yeah, it's a public document.
It's a collation sheet.
Which is a parliamentary election results summary sheet.
Yeah, now look at the last part. You know, that form has got the various candidates.
Yes.
and the marks or votes that they scored, right?
Yes.
Now look at the lower part, where provision is made for the candidates to sign or refuse to sign. Because the refusal to sign means that a candidate may disagree with the coalition and would want to raise an objection. That is considered and entertained by the Electoral Commission themselves. So how do you say that the order to collate doesn't affect third parties?
My lords, with all respect.
Because they have a right, even at the administrative level, to object.
Yes, my lords, under the CI 127.
Yes.
If a party decides not to participate in the process,
yes,
it doesn't stop the EC from performing their function.
Yeah, but what we have here in your Exhibit D9 is the sheet which has only the MPP parliamentary candidate's name, his agent, and his signature. There is nothing about all the others. There is no reason why they did not sign. So the point I'm trying to make is that even the form of the Electoral Commission entertains the fact that in the coalition, the other contestants will have an interest.
My lords, with all respect to you, in the bench, this document, D9 that you are referring to, this becomes relevant when the results are gazetted, and you want to challenge the result by way of an election petition. Petition, my lords, with respect. At the time when the court was making an order for Madam's application, this exercise I don't know if effective. But now, personally,
I'm just trying to say that what the applicants are saying is that they stood to be affected, and you are saying that they would not be affected. The Electoral Commission is saying that they will be affected. That's why they have this form, which makes provision for them, for all the other candidates. So the Electoral Commission, Mr. Minubo, you can also comment on it. Because you didn't exhibit it, I didn't want to spring it on you. But it was exhibited by the 2nd to 7th interested parties.
Yes.
Yeah.
So my lords, I mean, this particular exhibit D6, 7, 8, and 9 is contained therein were not factored in at the time when the court making an order that proceed to go and do collation and declaration.
Okay. Agreed.
Mr.
Merubo, if you
my lords,
yes, that's right. No, just one point. Mr. Merubo, if you have those exhibits, I think you should check them well, because D10, the form there is a bit different. So it will be of interest to you. You know, the D10, the form doesn't contain the portion for stating the reason why you
yes, my lord.
So it's of interest to you.
Yes, my lord.
Okay, thank you. Yes, Mr. Gary.
Yes, my lord. So, my lord, clearly. The point I'm making is that if there's public elections as they conducted in all polling centers, not declared in all polling centers, what is left is collation and declaration, summation of the various results in the various polling stations. Why should it be a problem, my lord? Why should it be a problem? Why should the EC? So, my lord, the point that we are making, granted without even admitting that the application for joinder, which we have said, my lord, is a non-starter, but the rules don't provide for joinder applications. If the judge has been aired, granted without admitting, the judge has been aired, the recourse of the petition of the applicant is appeal, not judicial review. Let us should arrive. I just want to do it before you this morning. My lords, again, one other friend made a point about where's the rules book? About we not filing a statement of case. Thereby making the application and the judge being biased. I refer my laws to Order 55. Two, 3, of CI 47. That within 14 days after filing this application, the applicant shall file such copies of the case as the registrar shall determine, setting out fully arguments he wishes the court to consider. My lord is the registrar. The registrar. Now, if the applicant does not file a no case within a time stipulated under Schedule 2, the registrar shall certify that fact to the court, which may dismiss the application for non-prosecution or make such other order as it may consider appropriate. There is nowhere, my lord, that the non-filing, restatement of case deprive the court of jurisdiction to detain the application that was before it, to the extent that the registrar or the court, which was supposed, if it was desirable to do so, made no such order. In any event, my lord, the respondent, that is the EC, that was supposed to go and carry out its constitutional and statutory duties, they did not put the application. They took the view that yes, they wanted to go and do their work. And indeed, my lords, they have gone to do their work, declare the winner, declare the loser, and the matter is foreclosed. Oh, foreclosed.
If that were the law, the illegality will persist forever.
My lords.
So I'd like your other arguments, but as for foreclose,
my lords,
your other arguments you have answered substantively.
My lords,
yeah.
My lords, an order by a court to proceed to perform a constitutional and statutory function.
If it's set aside, that would be. The consequences are clear in the authorities. Anyway,
with respect.
Yeah. Your other points I will take, but as for this one.
Yes.
Yeah.
Further, my lords, it is not the applicants that were going to perform the said constitutional duty. Not the applicants. It's the first interested party. So granted, which I already indicated that the joint application was not funded by the rules. Granted, there will not have been a necessary party to the action. Granted, because the application was directed at a specific body, the EC, and no one else.
Now let me pick your mind on something the trial judge said in the ruling in respect of the application by Nana Equia Owusu Afriye. If one of your assistants can open to that. The ruling in respect of the application by Nana Equia Owusu. Yeah, B series. Now, if you can read the whole of paragraph 1 and it extends to the next page, read it and.
Paragraph 1.
Yes.
SBB series. The application on the face of it is not different notwithstanding the submission of a friend of the court in the person of Godwin Eduji Kujo Tamaklu, to the effect that the winner of this constituency has been declared, and which has no evidence, and which no evidence is before this court, except an application yet to be moved. It is observation of this court that the respondent will not be affected if indeed it has been declared already.
Now you stop.
As it stands.
No, just now you stop there. You see, this conditional, if it has been declared already, where does it leave us? Because the applicants are contending that it was declared already. And then she is saying that if it has been declared already, then this ruling doesn't change. I'm finding it difficult.
Alos. Alos.
Yeah, you were there, so probably you.
Yes, Alos. The application, my dear friend, far before you. If you look at all the exhibits which they have filed, my Lord should realize, what is all this? My Lord should realize that they have not, or they did not, what is this? They did not, no, our application, our affidavit, yes, they did not attach any parliamentary election results summary sheet to demonstrate that, in fact and indeed.
Oh, we hadn't reached that stage. Because
then direct me.
No, the point I'm making is that the judge is saying that if there had been a declaration already, then the person whom it was first declared for would not be affected by this ruling. But that is a very risky, slippery ground.
The bottom line is that, let's say, even there was even a declaration in court, but there was none in court. If the collation is done and you won, it will be confirmed that indeed you have won.
No. The judge said it will not affect her. Anyway, it is not your writing. It's because you were there. That's why I wanted you to react.
There is no way that if you win an election, and you have won an election, the results will change. If you have won, you have won. If you have lost, you have lost.
Anyway, that is the dispute. The dispute is whether the first person won or the second person. So that's the dispute. But I must be honest with you that the application before us, we are not in a position to resolve the factual dispute.
That is true.
As to whether the person who was first declared or the person who was second declared. We are not in a position to resolve that dispute. Ours is to look at the legality of the proceedings that resulted in the order for the Electoral Commission.
Yes.
Yeah, so wind up and then...
So my Lord, in conclusion, I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record, which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that the High Court judge exercise a discretion. the applicants are agreed about the discretion so assigned by any High Court judge. Their remedy lies in an appeal. And not you. My lords, we submit accordingly.
Thank you.
My lord, just a quick, okay. My lord, with your leave, just one point of law. My learned friend in his concluding statement says, our remedy lies in appeal. My lord, with the greatest respect, without being joined and being a party, we could not exercise the right to appeal.
I have authority to give him. I have authority to give him to go to an appeal. Is it there? And I will give it to him. Yes. 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 The authority is there, I'll give it to him.
The court will take a short break. All rise.
Yes, I'm being led by
Dr. Aziz Bamba Bassett Osafo Boabin and Marietta Brew appear.
Good. First interested party. May it please my lords, Justin Amenuvo appears for the first interested party with me. With me is Hope Aguado. Hope Aguado.
To give me some little cost.
exercised had completed, and then the parliamentary electoral results were declared in their favor. In the processes before us, the first to seventh interested parties contend that the collation of results was not completed in those constituencies. It was in this state of affairs that the second to seventh interested parties filed series of applications in the High Court and prayed for orders of mandamus against the Electoral Commission, which is the first interested party herein. Their prayers were for the High Court to order the Electoral Commission to undertake collation in their constituencies and to make a declaration of the winner of the constituency election. In the meantime, the applicants herein had earlier on 16 December 2024 filed an application for judicial review against the Electoral Commission, in their case praying for declarations that there had been earlier declarations in their respective constituencies and praying for injunction to restrain the Electoral Commission from doing another collation. On 20th December 2024, the two applications were listed before the trial High Court judge for hearing. The first application called by the trial judge was that for mandamus by the interested parties herein. The Electoral Commission did not file an affidavit in opposition and stated in court that they were not opposed to the application for mandamus. However, Mr. Godwin Edwigi Tamaklo of counsel for the applicants herein stood up in court and informed the High Court judge that his clients were interested in the mandamus application and that they had even filed a motion to be allowed to join the mandamus case. The judge decided to proceed with the determination of the mandamus application and granted all of them in favor of the applicants therein. It is those rulings dated 20th December 2024 that the applicants have invited this court to quash and to prohibit the trial judge from having anything to do with the applications. The grounds of the applications were as follows. I've listed them in accordance with the motion paper. The interested parties filed affidavits in opposition with exhibits as well as statements of case in which they argued in answer to the case of the applicants. Before the courts could hear the application, counsel for the second to seventh interested party raised a preliminary objection and pointed out that the rules required that at the filing of the application for certiorari, the ruling which is sought to be quashed should be attached, but that was not done. The court indicated that the application should proceed and that in the final ruling would answer the charge. Our conclusion was informed by the fact that there was an explanation in the affidavit as to why the ruling was not attached. And we took note of the fact that now the rulings are before the court, and in order to determine the merits of the applications, which have been well argued by both sides, it was in the interest of justice to proceed. So we proceeded. Counsel for the plaintiff, for the applicants, first stated that since at the hearing on 20th December 2024, the trial judge was notified that the suit to be affected by the proceedings for mandamus, the judge ought to have joined them to the case in order that they could file affidavit in opposition to the grant of the mandamus. He further submitted that since their application filed on 16 December 2024 was listed before the judge For hearing the same day, the judge had knowledge of their contentions that collation had already been completed and declarations made in 4 of the constituencies. So he ought to have permitted them to put that evidence before him in respect of the mandamus application. Additionally, the applicant stated that the procedure rules on judicial review in the High Court, which were applicable in the case of the application for mandamus, being Order 55 of the High Court Civil Procedure Rule CI 47, made ample provisions for interested parties to be added to an application for judicial review, but the trial judge failed to apply these provisions and to add them. Counsel for the applicants relied on a number of decided cases, especially Public versus High Court Bolgatanga, ex parte Hawa Yakubu, 2001-2002, Supreme Court of Ghana Law Report. Counsel for the applicants further stated that the trial judge exhibited bias against the applicants by not only failing to admit them into the mandamus application, but by opting to hear the mandamus application first when their application for declarations and injunctions was filed earlier in time. In answer, lawyer for the first interested party relied on the statement of case he filed and added that he observed that none of the individual parliamentary contestants had an affidavit before the court in which they complained about any miscarriage of justice. Lawyer for the second interested party, the second to seventh interested parties, stated that he was vehemently opposed to the application. He pointed out that the applicants built their case on the failure of the trial judge to join them to the mandamus application. But he submitted that the rules of the court on non-joinder of a party is to the effect that non-joinder does not vitiate proceedings. He referred the court to the case of Bobier versus 21st Century Company Limited. He submits that the judge had a discretion given to him in the application for judicial review to join interested parties if it was in his opinion. If it was in his opinion that they would be affected by the proceedings. The trial judge did not consider the applicants necessary parties and he exercised his discretion against joining them. He submits that such order would not be granted to quash the exercise of discretion by a trial judge. He referred to the case of Republic versus High Court, the Republic versus Court of Appeal, ex parte Chachichikata, 2005-2006 Supreme Court of Ghana Law Report. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications without hearing the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. It is very clear to us that it was plain to the trial judge that the clients of Mr. Godwin Edoji Temaklo stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts, and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally, and Order 55 judicial review. In the case of Awuni versus West Africa Exams Council 2003-2004, Supreme Court of Ghana Law Report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. Godwin Edridge Temeklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Hafwano North are not affected by this order, by this our order, and in effect, those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed, yeah. Now, those which have been quashed, sorry. Those which have been quashed, yes. To file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court, ex parte, Ajua Company Limited, Auditor General, Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
My lords, we are extremely grateful, extremely grateful.
We are grateful to the court. My lords, we are grateful.
My lord, there's a second motion on your docket.
Respectfully, my lords, civil motion number JA/30/2025. The Republic versus High Court General Jurisdiction 13, Accra, ex parte, the National Democratic Congress. National Democratic Congress. Baba Sadiq. Erabna Oben, Amenope Philibert Fomi, Ibi Bright, Christopher Bayer, Akwesi Edusei, the Electoral Commission of Ghana, Patrick Yalbuama, Nana Ekia Owusu Efriye, Frank Ano Domper, Charles Forson, Martin Kweku Ejay Mensah, Eric Nana Ajiman, Inspector General of Police. Respectfully, my lord, that is so.
My lord, that is so, the same time. And the same representation.
Counsel, the same representation, counsel.
That is all, my lords.
Okay.
Let's replace that person with Nana Befi Yeboah. Nana Befi Yeboah. They will replace Nana Ejay Bafo Ewa. Nana Ejay Bafo Ewa.
Nana
Ejay Ajye Ajye Bafo.
Okay, no.
Bafo Ewa.
Yes.
Ewa.
The lawyer,
yeah, he's a lawyer.
Yes, and then now MP.
Yes.
MP elect.
MP elect, yeah. Well, for the 2nd to 7th interested parties.
So, Bafo has been replaced by Nana
Befi Yeboah. My lord's Befi, Baafi, and then Yeboah.
Okay. Thank you. So, what is the fate of this application?
My lord, in view of the fact that the orders we're seeking to stay have been quashed, we will seek leave of this court to have the application withdrawn.
Yes, Mr. Menugo. Any opposition?
No, my lord.
Mr. Dimako?
My lord's no objection.
There be no opposition or no objection to the prayer of the counsel for the applicants. The application for stay of execution is struck out as withdrawn.
Extremely grateful.
Give me some little cost.
No government.
I think when you finish the whole thing, when you finish the whole matter.
The whole matter?
Yes. Yeah.
So you are being moved into all of this. You notice that you didn't file any processes. And it's understandable because your role is very crucial. The role of the police is very crucial. You see what this application has done. During the application that we should do. You should let me go to the scene. We all have to come. We decided that instead of
adjourning for a judgment or to give you a ruling without reasons, in order to forestall any unnecessary comments and therefore disruptions, that is why we constrained ourselves and did this. So also play your role. As a convey to IGP, you play your role. Neutral persons, and then make sure that we avoid situations which can lead to an escalation of any disruptions. Okay? Okay. They are not here. There is the lawyers who are. At least there's a general secretary here, Mr. Fifi Kwete. Yes. Yes. We also think, as we are talking to the police, make their work easier. You, the political parties, make their work easier. Try and then also help so that we have a peaceful atmosphere as we go forward. Thank you.
All rise.
These are changing the results. Yes, nobody has been looking. That we have got one solicitor from that. Is it?
So I am trying to get some of the legal representatives for the parties and some of the political party parliamentary candidates that were elected and their decisions were quashed. I want to get their... So I am trying to get some of the legal representatives for the parties and some of the...
Okay, so observe na the ekosi no na say me no kan idea sesia no electoral commission case na kopie mo court no. Okay, so observe na the ekosi no na say me no kan the tiane say electoral commission ene idea wo ye no the tiane say right and mami na munyina ma senti de kosi ye ne say mami emfa we ntu dwa say wo hwe high court decision or the buy in the beginning no wo tie no mal o cast electoral commission ko ye na dwuma no now Supreme Court to transi no yenye ne say na ye 6 out of 9 and then the Supreme Court to trans 6 cases so 6 constituencies nti omubo nkro ni nyina wie ye no Supreme Court to say the NDC for ka say High Court judge na mo fair hearing no say no aye no o kan kwe Central Ablekuma North Tema Central na Fetachima South omo hwe nkrata mu no o court no ahye wo mo say no ahye High Court say wo mo fa different judge na wo mo nsan kotena saa for constituencies we so bio nti pacho yen hye nson in order say obi abenya fair hearing in the court of competent jurisdiction nti Okake Central Ablekuma North Tema Central and afei Techiman South for constituencies we know the Superior Court of Adjudicature with the Supreme Court to say one mon sanko bio na wo fa different judge na afei no one mon kotena say na judge na international one san trans case we bi ne hwa de afei Supreme Court sa ka bio say on 30th year di enemy year 30th December year no SS High Court meeting sa for constituencies we na we make a determination again afei Supreme Court as actually him say 2 of the constituencies which is Nsawam Aduagiri Afuano North sa wo decision no mo ruling na say declaration electoral commission here no it still stands say the MP elect Anodompre or the MP elect and then Afuano North Martin J. Kosa or MP elect one more the it is not affected by the Supreme Court decision. And 6 cases no more call ye. Na me in fact near expect to say 7 out of 90. I think see a very near one case, one constituency. Yeah, who or more Supreme Court case with me. Right. Nti abusia sade etie no Supreme Court asema waka no. I mean on the court nyina about time. Sabaye na basabase yobia ma no. Na obi nya trimupo bia se bia a High Court aye ameki a determination akọ in favor of others no. Mimi gidi say Supreme Court decision odi aba no say monsan go back to High Court obi no. Mimi ne ya adwen. Pacho wonso so say na osi hu no. Ni nyina no den ye the rule of law na wo no chekere wo man ne friend Ghana no. Ye the rule of law na chekere wo man ne friend Ghana no. Nti sadia tia no nti yentie mame fan kokot obi na yentie candidates ne ba court won bi na yentie won so said o me de tuda ye be sa ba bi hide the reason so from ode sheba me da busuafo nyina ase wa utimi like video no me da wase proud African me da say me ba sisia
Mr. Brew present. What does all this decision that was given or the orders by the court really mean?
It simply means that by Monday,
we have to file the affidavits in opposition to the application for mandamus in respect of 4 of the constituencies. The court has also directed that hearing should take place on Tuesday of the application for mandamus. So it's as simple as that.
So generally, were you satisfied?
Oh yes, generally we are satisfied.
Thank you very much. And you just heard Marietta Brew, one of the legal brains for the National Democratic Congress. We are scouting around to see if we can find anyone from the side of the New Patriotic Party to share their fair comments or their comments on the basis of the decisions of the court. We see a number of legal brains from all sides, who were in court, and we see.
Because I think the Supreme Court's decision is even hinged on the Alden Ultra Partum rule that let the person be heard. So the mere fact that there was notice that they had an interest in it and they were not heard, the court says that it's been elevated to constitutional right. So even administrative bodies, when they are bound by that, how much more the court? So it is only on that decision, and they are saying that the ones that were not declared that there was collation that should stand, that is in Sawam and Ahafano. The ones that had been declared, they should be given the opportunity and be heard. That is the 4 that they mentioned. And if you look at it, the court process that were filed, it was on the 6th constituency. But whilst they were doing the recollation, they did 7. So I'm sure the legal team will sit down and look at the other. I haven't heard anything about Obuasi East. So I'm sure the party and the candidates will sit down and see how we go forward.
All right, thank you so much.
It's a pleasure.
You just heard Kojoga Adawudu, who just addressed the press briefly, giving some explanation as to what these whole orders by the court really mean for what potential ahead. Generally, let me run you through some of the critical decisions taken by the Supreme Court today. The Insawam Edrejiri constituency will stand as it stands now because their collation was just done once. We were at the Tesano Collation Center where some 2 constituencies.
Abusafo a mutie the reason show. Yebeda mu nyina mo ase na said ade no kosi na simple. Supreme Court 5-member on the bench na enipa 5 judges no 5 and the tena bench ne so. And judges no in fact omu nyina no ko benkrum 5 member na bench ne so nyina no womu nyina and final determination we buy on my orders no. And for me hu say omaya ye de rule of law chichere de say ya na say ekono enya tutrasem enya gidigidi na we will show you where the power lies. In fact, we share emrantie na back or obi to say Sadiq Adams and now say and I ye de violence no one ye de PNDs. Now you will come to court. Oh, oba court why e ho ne yemfam violence ni gidigidi na ye ho. So, till now court to direct to say go back to high court no. I mean, when I saw your homework so when I saw your homework na open judges are lawyers on betimi ako face high court judge na mo de exhibits ni evidence ni kwa akushia no so enye gidigidi sem kra enti in oman ya di rule of law chichire oman de ye nya sa incitement ne eniema gidigidi na ya na ye the street ne so no sa enye good precedents because we share the nature of the Supreme Court now here the atmosphere. In fact, when you big case kura, when you big case as I say, yeah, at DBA because electoral commission on so in this case, once electoral commission, yeah, even high Supreme Court and citing for anything, say yeah, that woman new right somewhere the only high court na on all that say electoral commission kokoye wakuma so. But one thing I'm hearing case we must say the MPP and I say the other parties now no more interested party to say the MPP for no lawyers and so no In fact, omo so transema the media ni use a term called recollection. So study court to our say Supreme Court never say recollection because Electoral Commission continuously will catch say any recollection a year continuous collation. But so here all the media houses use propaganda be here na recollection. Say I say why yeah be to study all media houses now once almost share that year recollection. So no the MPP for any amount communication no. Na we no me giri say MPP for no be sua mu nyansa papa MPP for come Woma chese anyway we MPP ni a we mu nyina no you musua bi frem na mu ne mu mpanifo na hunu because me hwe proceedings no man hunu ba bia so wo say recollection bi o ba bia but hwe the media no so a no ma churche the Electoral Commission recollection ni nyina ye big blow ni nyina na ye strategy court the or dealing with the evidences in a factor the abeguna name. I mean interesting. Say matna my media no aye the propaganda bomb mafia still. It seems that the MPP what leadership on any woman communication no and hwe ase kra. My media no be abiti woman anyway. It is said the abusuatia no nti 4 out of 2 no they should go back and on 30th and 31st no we will see the fairness in the high court. We will see the fairness in the high court. Right. Nanabra mamincha enye izo nanabra now there me odwene ho a wo de hwade. You see the momentum. Would they see the momentum on Supreme Court? The NDC momentum in the Supreme Court, the support, and check the MPP. You don't even see them. You see, their lawyers are even representing them. Anyway, MPP for we there. Proud Africa, thank you. Okay, my young na. Yewo a live be be sad ya ba ho na ye nhwe ye stream ye ba be ye do court ye be stream bi sisi anti ye be sa ba bi na ye streaming ye mfa ye live win free TikTok sombra right ye wa stream bi ye streaming live nti ye na busiafo nyina se ana me hwe among for person mo kire mo adwa ba comment section ye mie phone line ye mfa 1 or 2 bi ne hwe the who no Supreme Court no said you see who na but ye mama mfia se betuma for 1 or 2 calls we 024207 3114 plus 233242073 3114 na ye mfa 1 or 2 calls bi mafia se kapa ye de mama mfa number bi nto ye mfa 1 or 2 calls bi na the who no Supreme Court we na ye hwe cause asem case we na a sensitive case pa case we na a very sensitive right eti ye hwe I mean for are you into 233 242 right I mean call I mean ye for call my fear na to say yeah, who you are, now the course of Supreme Court to you who say.
Oh, this year, Ghana na democratic state. It is a bibi or na one ten once year. Some of the court, wouldn't even say what the mra day. Shawnsome. Said the name be a tretina. Yet the revolution is never become with the part of Ghana, yes, I get to you. So far, so good. She said the Supreme Court here, you know, no pass one. I said, a high court no think on handle case. But now NDC for big to say there has been a bias, a cotia NDC for and they will go to Supreme Court, normal compare fair hearing. Also say assembly on the channel, baby as a fan sana, about the do baby one. And so far so good on this is in the maybe want to say very perfect. Now one thing about MPP is MPP Nankasa woman is very stingy. A bassa yen cheers come media, a woman casamoma, Debbie, Omuntia, a bassa, communicate person also communicating no. And boy, support will be to say transportation, any data cry, honestly, I'm say bloggers are never social media. No woman NPC for providing data.
That's right.
Found say, yeah, all viewers are now winning viewers. So far as your message is reaching people, no data. Send me a bear. Who bet me I get you a day and a day, and the amount. Many more cases is here. Me say, what was that for now? Here, 2 are many, people communicators, and they cannot come out, especially what TikTok on YouTube, Nadia.
Yeah.
Say, they will not come and back.
They will support you. Unya sama, and this one unya so and people support you. Amunya. Very diabolic party. Yeah.
Now I was thinking, say, blogger or not me video about 2 months or about the chimney. And not all threatening. Not only say, not empty for who could that message, but any woman.
Yes. Yes.
Political party be no they don't respond to your home.
Yeah.
So I will send our senator.
That's right.
And you are trying to say, next time, no, in the new one, you're about to form. So, or the sign Abeco, no, the amount. The answer is no. So, what's the MP before also? Mistake about what I want to say. What constituencies are? As I would develop on. Not be a develop constituency to a background.
Yo.
And only one factor. 2, our factors on we cannot say, how much I had you, my dear Amon. 1 for where you mamu. Almost say, yeah, I'm a gun of winner.
Yo.
But NDC as a party bar, on far the members in here, on far outsider.
That be.
Mistakes are. MPP for a year. Nothing you could form my quenya. Almost sign back, but Trapo Yamaswa. And you marketing kitty, what's your woman? One communication team. Or what I'm fast share of constituencies. Or what will be a semi back home, send your way and free NDC. Until then, they remain in opposition to say, will be able to say, and Topadea. Or back home, mamma support.
That be. I'm with you, cry.
So you people don't have the platform to campaign, and also one factor. Into
me da se papa. Yemfa the next scholar. Yemfa the next scholar wa say. Yemfa the next scholar. Asemo. Right. Yemfa Jinya minute say. Right. Now the course of Supreme Court you who say.
Share with you for more about Snake Madian way. According to media. And Yamuaka and Yamako Sufi and to be empty.
Right.
And then your course was sportsman. The Quanswan. Yet, Mr. said, and this is the call fair. Omode Assembly Call High Court, or no Assembly Call High Court.
Yeah.
High Court, no, I'm more Muquine, I'm more ancestral massive. The Supreme Court in the wire the writings, the Munko, na Asama Munka, na High Court. I'm saying the writing no Maya.
Right.
But no many about as MPP Unia Sama, say the judicial or my own. The essay, Yadisha and Concrete say, or mine and they are paramount. Then you are in this for you to trust me. Then this MPP Sukas or no, so yes, or man Yunku. So, though a new to NDC benefit at some point, but say, do you ever do baby? I will say, or mine, you in fact, to trust the moon, NDC, yeah, only call coach. Yasabom so moon conco massive. Sebi judge is name and Benifono much on Mukon massam na. A toss ma on Bitsy, but say Asamno air can and toss ma on the work. And me, you say, say a 2 baby, and your court need decide Serena, Arena, and Serena. Called pink sheet, on the face of pink sheet. I took by the catcher, the only rainy election. Say, when you be out this year, I can't pink sheet, Nina, found the bra. Nayan Kaidi Unya and Madomeka said Tema, former Greater Accra Regional Minister, and outgoing Greater Accra Regional Minister. Yeah, all the 3 votes not even Tema. It became famous cliche, say MP3. In Japan, they are 2 you been out of the one winning. But when I say Kayana could do Babylon, say BNP lose election in Najitum. But then also say the any parliamentary seat. The Takashini and free in some. It me Ogidian regime say go back to high court now. The MPP will be vindicated. But the additional community say MPP for mobile bank your money because it never be break or swap. I have party for man. Who ya MPP ni mapa? Who can compare Juma? Me and Mino say, as an MPP by UK. A Juma Beda airport. One alcohol will be a
Nanyano na ye nua ba yi kai eno na ye nua ba yi kai obia was our complaints we MPP for complaining about omo penifo emfa wo mo ho enna mo di ya no munya voter apathy no eno a enye bibia bio
I think they're going for it no almost less no more say at least who show the year always which me maintaining Ashanti region Kwani Eastern region when you almost 70% of the total vote into when you calculate the other regions now can be better now by more for so many years but sir and you may can once me but me twin say ye ko ye nimu on be sua addition dey free mu na fe o mo tumi ayere ahwe o mo dey but ye nya rehye mu say high court na ekona yete frawe ase and ani be buti ba me dey mo gidi say o mo nyinjeche mu papa bia because Takashi no mo dey say o mo declare o mo candidate because o mo say nationwide no MPP was losing but MPP lose election and just say be obi are any parliamentary seat yinjinchim nsani anyimfre ni sem
Mesome da say okay but that's a pa yemfa Kwadwo Black right I was hide the reasons we are from audition wait my like if you don't know we know subscribe to the channel you we ya mpacho ye what the live be to us when they stay here why you we the live be to us when they stay here why Kwadwo na to say hello Kwadwo Black hello Kwadwo Kwadwo Timenka okay on Timenka ti yem for the next caller okay I'm some funny here hello yeah Kwadwo boko there right my inti the course or Supreme Court my inti was worry
MPP plan
I can asemo
and a party beyond your won't go for and your deal for the moon should be a better from party be your from me personally is what is about that life party be now down for now a moment of home and maybe want to be crossing yes some to come to be cross party your own about that for crowd so what you see and maybe a chair Canada Japan yes would have had 92 ban would be to see your call I Katamatu say someone for register was la usu no for question up no ne kana sorry no why press conference that for ya be bia na the question no I think the governor ma bia vem no bia ko so what you see
yeah
and e ba ya na fe na abronya no e be we mu ne ka mo sorry no mu ta ma fuachi afi na boxing adoye ono na no kufu ado obi ko fa say na okofo oba bi wan o sa do na omna na propaganda na die PPH support won omo ye dirty work no ba masa mu nyina ba wi ana ye party ni akofo won botai ye yisa akofo ni na ma be later ni ye twa ma chi akire won
yo
nana asaya reho omo hwe ni ye ntina se se so bi andi o ma chi because e ba ye omo kwa na edi omo bo mo no mo nam se mo ye omo ma
yo
ya reho eti esi bu wi ase wo wa bia mu nya wa brabo bia mu nya ntina obi ni security wo ko ho abona fofo na wagwa to nyi na ma ni bi ko na obi be obi bia wo na ba be boa wo sika mo obi ni e wa brabo isra ma be before mu dia asi obi andi o machi o because mu discourage mu nya post mu pamo mo be network ni propaganda for ni na sorry ma pamo mu nyina abronya wai ko si adoye wa he se ken 92 ba nyina wona esa adwuma no wo sore ma fu question ni nachi se o wa he ya sore tia sa ko fu nyina ma ko fo mo botai omo de omo tia gochire o bibi ba like this omo koye o omo musika dada yes sira mo wo de bibia ye obi ani wo so ma mo omo nyina ye mo me hwe se hey it is a one best sore ja ama MPP omo mani e de no mo wa he abronya wa he ko kra do ye no mayi na di no one to no more yet, to say, I see, baby say no for baby, but because I my suspension. You hear the pass, me hear the pass is here, Pamunipa. Yeah, position says, we are month work, before we year one. I don't think pass up. Probably my winter, yes, or we are mamma, you want so more one year, no more. I brought your way, books at Diana, where to work in Papa Mono. Papa Monia, Mamma time, was this year, and one of my could not go to Opian, much my money. Cafes now, your branch, you must see, Oxadoy, no more, a rap of 1 year. Party, yes, I'm for 1 year, you know, where I did work. Neither I never pay attention. To say what you would need, Mumpas Mumpa, what contract discount. Mamudia, I, which I'm around was some MPP, and I said, Western now relax, you won't get it to European wow. The Sram, the Benefomutia. Munko pass up and Pocopoli, that you will throw now back, and the Mutia said, we are month working. You hear the Palisano, what is the original by one and I'm where you say, we have to unit. We hear the pass, we hear the partners, we hear the just had your money and become 1 year, and maybe can the podcast 1 year. A bit of Mama and a book of foul. A bit much. What's the big much?
Yo.
And now, Cardiapon is also a prophet. This will be any much you. She said, some of Mama. She said, some from now, before now, by press conference. The pastor said, why are you going to be a factor when I'm some back?
Yo.
Yes, I wouldn't with
you. Yo. Okay, could you know me that say? Your father and scholar. Now, your father and scholar was a. Ayasemo nti adidija de ani muna ne nam o adidija ani muna ene nam sa obi opoto no nchiri se odi bom adidija ani muna ne nam ye fala scholar wa say why be boko there
boko this sheba
that's right now Supreme Court who say
the person mechanic Supreme Court no Sasam Bessa High Court for no nase omo de pepeye ebeye adwuma because na no ya video our boy program is an free city Sam Georgia as MP war force EC officer so on be declare we EC officer no so declaration ni mu na o kan say 110 polling station out of 140. Obia said we are reasonable piano. Yeah, two abana says 110 polling station, I cut 30 polling station. Meanwhile, so parliamentary to say presidential 50%. Parliamentary will beat me crowd the 10 vote.
Now even one vote to crowd the arena, one vote. What the arena?
Until the empire may bonus a Supreme Court no quiet. Na fe akoye nsana hobia ma because basa 2028 no any Ghana nipa pibe because MPP for so be here say any o ba bi o mo so be twituo akosi because nya DC for nkwa na wo mema MPP for so wo mema ni bi wo Ghana dem pese me kan no na eba unemployment yin so a omo kana Ghana no unemployment rate no na ye high papa. And it's going as a men tried your SHS. Me share from 2019 or 2018. Ebeka la early last year before Nipa and the MPP recruit mobile men kwami school on Bebro 30. Men kwami school na me tried your high school. Okay. Senior school. Ashanti region.
Yeah.
Men kwami school on kwano. Do find average, almost Papa just an unemployment rate near higher Nintino. Still, now a nipa of fear, a year almost be say, MPP by Oman Yajuman. But thank you, say, ye shepa by our funny papa, the Anko, me so real Nelson and the President Mahama. But when Yajuma, a good father by and son Unya Nakoya and a good bear some man sans and Unya permanente. Inti, and not dear. A honum they drew on my door, a bebo ma. I just say, you meant man for be but a honum no so be a do on my beckers or more yardie. Timothy and Pesa Mecano.
Okay, Medase pa, why be Medase? But Obian stay here. I mean, the live feed is free. I bus here to associate to stay here. Madam Wasepa, auntie, I said, you know, cano, Bibi Obian, a farmer, a consul, auntie. Young farmer are constant a cracker, the democracy na ye burden. Mammy knows your phone, I say. Na me nam wase na another show so yes so best check studio 2 say anti ma me nam nyina wase nana bra me chiao nana bra wo mo nya sika wan pipi hunde wo mo ni wa nya sika bo e wo kwambo ni bia so ne de mahama ne kasongofo no mo twen o wo nko a wunya na wudi a wo nko a obe Joseph wa pampem nti wo de I crossover na de Supreme Court High Court ne ya court crossover na Proud African Proud African crossover ya be kwa go di no High Court MPP ni bia wadi sika boni bia no be fe wudi na ma obibi di ya e ba youth no betu adu achi wo mo be hunu na betu adu achi wudi no nkwa na wudi ya kura ne ya do ba akoma kasongofo no pa bonefo a mo nipa bone sem egina wo mo afa ye ko kan na mo adwa mo ma boys yi adwuma nyina ma na mo de brofo mo ke ka brofo se ko kan na mo bu afu pa bonefo me se kasongofo no ya na ye de mo nyina be ye de mbeko wa wanya sika bia wudi nyasi ufa sika boni bia ye ready kasongofo ne twen wo ko kan na mo adwa mo anu ya ho amafo yi adwuma boni agbo adwuma mo fi wo obi obefro bia ya wan bibi ni di na fam oginu wa wonte ase ada emu kwa na mo ye yesu nsia na emufo mo ye nwe ho amafo ko ye adwuma mamo na mo ke kabrofo na kofa certificate bra e na wo de unqualify e na ho anwan mo ye nwe ho ana hwe ko hel enra letter men saka me de bebe life NDC I issue letter dia mo party offices mo fa mo nkrofo mra me de letter ne ba beto me de beto e chene ba de ba be full life mo ye nwe ho monko ana mo ye atene nefo oko ka do mbu afu o de wodo amode beba mo ada na mo visa monko ana mo tete brofo sa monko ana mo ni brofo ka no mo ke ka brofo no ma yo mo so monko ana ye gentle fo bi e de ne hu da anyway abusafo me da mo nyina mo ase me da mo ase ye be soldier si wo mo so empanifo no ye one after the other obia be di kumbe one after the other obi adwuma oye bia se no ye be call constituency ba constituency Asante region ye be di ka be hwe wo sa constituency le wori nyina no obi MP bia adwuma oye ye ba be ye be diagnose MP bia adwuma ye be per reporters agina ba bia MP bia ye be check wo mo ye se mo ba be hunu no bi ya puto constituency bia MP bia ye ba be ye be so ne wo so ne ahwe de wo ye wi aya ko DC ye be hwe what do you munya wotre your friend what dey ba madam nyina mo ase yen switch to studio 2 why madam ase there's another yen ko studio 2 video bi that so say you call live say madam ase your friend what dey ba madam nyina mo ase mo ase nyina madam ase Joseph Mohammed ase my fiancé kapa madam ase pa madam nyina mo ase eno kra de o kan wa nkan wo na wudi yawo enyo nko na odo ndo pipi nche wo bia ba dia mo mpanimfo mo leadership no ye no tai MPP leadership no most of them is so greedy mon kan okre omo ye greedy e de no omo nkoa na to efi so omo ye gentle mi anwe o mi anwe o kra abusia yanko yanso go studio 2 me da wase